All right, let's see if I can just pull off a short video and discuss, well, something that I think is on everyone's mind, or to at least some sort of confusion, to ascertain how we get caught up in the court system, how we're relegated to the courts, having more rights than us as pertains to our own lineage, how we construe the monarchy, and even some people saying, well, the Pope is has more controlling interest over the monarchy, or the monarchy is not real because it hasn't gone through the proper rituals, and you don't get any. The courts are all admiralty jurisdiction, therefore you're not heard based on your human rights, and just on and on and on. And hey, listen, I was where you were at one time, and to I realized some core foundational principles that help me assess where the core issue actually exists. And so that's what the video is about. Because again, I had received some comments, and subsequent comment by that last video I just did, in relationship to the group Peacekeepers, whereby their return or their volley was back on the concept of extracting the principles of equity law to give validation that it overreaches the law. Okay, so what this video then hopes to arrive at, and thereby point your interest into the right direction, is to comprehend that we are making determinations based on our own limitations that are principally affected by the fact we do not comprehend what law is. In fact, I just did an exchange with a real estate broker, LLB, so a graduate of law, something to that nature, a bachelor of law, I can't remember, undergraduate of law. And when I explained to him, the foundations of the basic principles of the law, he more or less returned, I don't understand what you're talking about, nor will anybody else. Well, in essence, he's telling the truth, because he was never taught, nor the government have ever been, given the authority to express or explain to you what law is, because that is not their agreement, what the agreement is to. The agreement, and maybe that's the best place, maybe to just bounce right off from there. How is it possible that they have all these controlling rights, and why is it they don't explain to me what law is? Okay, so here we go. We have come to understand that the English law is an evolutionary system of agreements that existed through reaction based on people having, certain or wanting certain control of land interest, predominantly and after executed by the Doomsday Book of AD 1086, whereby all land was in right of the king. So the king held all land, thereby created from there interests that were subject to a service or a fee, which then, if you made or wanted an interest in land, more or less a manorial estate, you had to individually agree, subject only to your own life, as it was a personal agreement to hold that land interest in right of the king, and that then you had to fulfill that service or agreement. Generally, it was night service, or some sort of agricultural service or surgery service, that kind of thing. Or you had to pay for a fee if you couldn't fulfill a service obligation, to which that was only heard in the common law courts, which was the king's courts. That is where the only place where it could be heard, and only those people who held immediately under the king that legal interest to land. Okay. From there were laborers, if you will, who worked under the baron, that then had to work the land or provide services within in the land in order to keep that land manorial state interest. That was not seen in the common law. That was in the manorial courts that executed any justice within their own territory. That was, again, those people, the laborers, just put a broad stroke and said we'll get into all the different layers that there are, like such as copyhold agreements, that they were not seen by the king. The king did not listen to those matters because he had his tenants in chief that were now controlling that interest. Okay? And that interest is only subject to common law, so thereby any interests that were managed under the manorial estates, under the baron, were not legal title or not seen in common law. Okay? Then there was the group of the church. The church is a perpetuity instrument, thereby is not based on a life for obvious reasoning. So the church had a use to land held in right of the king. Okay? But the king never recognized that right, inasmuch it never was brought before the common law courts. That's why the churches had ecclesiastical courts to hear their matters and remedies therefrom. The Jews, okay, another race or a group, so therefore they couldn't individually die because it's a race, it's a perpetuity instrument again, it's a group dynamic. They could not be seen in common law because, of course, that's not, again, as I will keep on saying, it's not a life. Therefore, couldn't hold a personal agreement. So they had their own courts. I think, back in the day of Christ, they were called Sanhedrin, and I'm not sure that carried forward under the feudal land system, but it doesn't matter. They had their own rules to which they were the bankers that then could not control an interest, so therefore could not create a lien against the common law because the common law A did not see them, and the king held all rights to the land interest. So they had to create liens against the fruits of the earth. Okay, that then secured the debt that they gave to the loan to the knights or whoever else loaned from them. So as you see, each one has a separate interest. Each one then is a different subject matter. Thereby, each one is governed by separate rules. Now, over time, tenants under the barons wanted to control their interest of land. So they may had maybe, there's 3,000 acres and a manorial. I don't know, it's probably a lot more than that, but just for sake of just making the discussion. And a farmer had 10% of that, so he held 300 acres. He then, of course, had people under him to manage, and he then said, well, I want to control this land, but he couldn't control the land in common law, again, because it's not seen in common law. So how do you do that? Well, he creates his own titles, then he sells those titles for those other groups to control maybe 10% of the 300, which gave them 30 acres. Then he was now the landlord, so now he was made, if you will, a lord in its own right. Okay? So over time, as we learn through the Statute Cleum Taurus, we then arrive to the Statute of Uses and so forth. They were a result of the issues that were caused by people creating estates that were not seen in the common law, and that they were also created states that served to circumvent the common law, so those who held the title can circumvent the incidents and wards and escheats and so forth that were owed the king. It was just man making up new devices and making up new rules in order to control an interest in land. And every time he made a new rule, created a problem that had to be remedied, and there created the courts in order to remedy them. So essentially, ecclesiastical courts, those courts that have perpetuity instruments, became courts of chancery. Okay? And we've learned that. I don't need to go through this. You can go through the England law series to see how we arrived at that. Now, do you see, from when I point out, the elephant in the room? How can equity law, from which the titles derived were essentially subject to the common law but not work seen in the common law, but are derived from the common law, how can they be greater? How can it be a more powerful law than the law itself? And I'll tell you, it can't. It's impossible. For the fact, it's a different subject matter. Subject matter, along with status, creates jurisdiction. So subject matter, if you were a knight, the baron, you had a different status, therefore a different controlling interest based on the common law rights of that title, immediately subject to the king, and therefore you were answerable to that and that only. The king did not hear your issues on the manorial side. Okay? He could not hear them because you didn't have that right of the king's attention. And then if you had issues with the baron, how did you get reprieve? Well, you spoken to the courts and created sort of juries and so forth to hear your grievances to see whether or not they could be then brought against the baron. Those were those courts. And then again, the church courts can only have a right to the use of the land because they were perpetuities. No one ever died, so they couldn't be seen in common law. They had no rights to common law, nor did the Jews have any rights to common law, to hold a common law interest, but they could create other titles thereunder. Each one, again, and I stress, is status and subject matter for each one. You could be, the settler in the dynamic of equity at the very top of the level of the trust that was created before the uses that are now extracted for government, or you can, under government, create a trust and be a settler. See, and then because that's a different subject matter. You become a settler of that subject matter, and you can become a settler to the originating trust for the government to use, which is the one that we're interested in. But you see, they're the same words, and that's the confusion, is everybody's using one word to describe one thing, but not realizing that each one is subject to a certain subject matter, therefore is administrated through a certain law. So natural law, you have inherent dominion rights, as we've already explained and expressed throughout the series. You cannot be removed. You can't transfer that right, dominion right, because everyone has it. The only way that you can lose it is if you do something against natural law to, like, say, murder somebody or something like that. Well, then you remove your rights of dominion automatically because you're not responsible for that power. Okay, that's the only way you can lose it, is if you do something, a major, you do a major crime, a felony, if you will, against another man, another life. That's when you lose that. But you can't lose it. It's non-transferable. But it's separated from the common law, even though it's the hierarchical, because it's common sense. I mean, man was given dominion, and by the very next sense that it's man that creates titles. So how can the title ever be greater than the man? Same as how can equity ever be greater than law if law itself was the creator of equity? Okay? So we have to use simplicity when we're arriving at any arguments and any issues, because what's happening is we see everybody's commingling ideas. Well, I am man, so you got dominion rights. I've said this many different times, but I think we're really getting to the point here is I am man, I have dominion rights, I have power over my kids, my lineage, and everything else. That's true, but that's not true in common law, and that's not true in equity, because common law, the agreement in common law overreaches your dominion rights, because the agreement is that which then is in honor and thereby creates an obligation. Once an obligation is created, then the law looks to the agreement. It doesn't look to your dominion rights, because your dominion rights are not seen. They are separate. What it does, what can only the law look at, is the agreement. And what's the agreement annexed to? What's the subject matter and what's the status? That's it. That's essentially the basics of everything. So if you're caught up in any under government courts, what are you under? What are you tacitly or expressly agreeing to? And as soon as you argue the point, well, it's my property or my kids, you're arguing the point under government, which has a right under equity law. Okay? You're arguing at the lowest level. You're arguing like slave status or servant status. As we know, the government is a master-servant relationship. So you're a servant going to them and saying, this is mine, and everything else. No, it's not. What is it's yours based on the obligations that you've agreed to, subject to the rules of equity, to which the court can only look to. They can't look to, they know, they see you, you're living, they know that you got dominion rights and there's common law, they know that. Okay, those are learned judges. You know, I don't think that maybe every judge understands everything, but the bar union, most lawyers definitely don't. But, you know, they're looking to you, knowing that you are breathing, knowing that you also have access to common law. The common law is there, but you're coming in equity, so they go to the agreement. But what if you went and said, okay, now I'm going to deal with the common law? What agreement are they going to look to? Okay, and what status you are bringing in order to seek remedy according to that agreement, because that creates the obligation to then for the court to look at to see whether you're fulfilling it or not, or the other party is fulfilling their obligations subject to their oaths and whatnot. So no one's doing anything to you. There is no fraud. Okay, there's frauds within each system. Okay, but there's no fraud that because you're subject to these admiralty rules or laws of merchants or equity courts, because we're just looking to the agreement. Okay, I hope that clarifies everything for you, because I think maybe this will help, imbibe the power that you have, that you've always had, show that you are the one with 100% responsibility, and it's only subject to your own free will, that is relative to the agreements that you're making, dependent upon the law and the subject matter that you want to seek remedy for. Do not go in these courts under frivolous and vexatious arguments like the freemen and sovereign movement have done, because they're commingling, as we know. That's why the courts can behave and act the way they want to. Is if you do not know what law is, then how can you ever speak to your full inherent power, which is dominion, to then effect a right of reversion in common law to that legal title held in trust since your birth, always sitting there waiting for you to finalize and take possession? Because if you do not do that, and as if I mentioned in previous videos, as a mortgage creates a brand new title, therefore all titles are now mortgageable, not seen directly in the courts like they did pre-1925. To now they're going to move into 15-minute cities, and those are brand new titles, to which now has new laws. And those laws will be, don't matter if they stomp over your human rights, okay? They don't exist because they're dealing with the agreement under the 15-minute cities. The agreement comes, but only the court can see. That brings in remedy for that law. It only focuses on that one thing. Just like if, a better way of saying it, if you're under U.S. under U.S. or territory law of the U.S. versus that of China, well, human rights are a different violation, but they're not looking at those violations because looking to the agreement. And just like your own house, if the kids go into a different house, they are subject to those rules of that house based on what the father and mother had put down or established in that house. But when they come home, they're subject to your rules. It's the same thing, okay? So not to beat the dead horse, but here it goes. The church doesn't have a right to the common laws. The Jews don't have a right to the common law. The entire system's under Jewry, under banking. So you're just agreeing to a title under that system. And if you don't get rid of it, you're going to be moved in. Your property is going to be moved into 15-minute city concept, because they're going to usurp all the property, not by an iron hand to say the elite that we're all powerful and we're going to take it and just because we can and we got the might and we got the army. They're going to do it according to law and your agreements to own property under the government and their systems. And with that, God bless. And I mean God bless, as I have mentioned before, just in the previous video, 43. Best wishes.